respondents, the Department of Health and Human Services, and its head, Tarna Gilligan. In this case, there are two issues. One, whether the Affordable Care Act or the ACA's mandates of contraceptive passes the rational basis review and the strict scrutiny standard. And two, whether Monkey Mastery meets the religious employer exemption underneath the Affordable Care Act. Monkey Mastery does not have the right of free exercise of religion and therefore cannot sue based on it. Monkey Mastery does not have any supporting case law for this claim of the right of free exercise of religion. What they do have are cases, Citizens United, which specifically talks about the right to freedom of speech. And even though they are both fundamental, even though they're both First Amendment rights, they are fundamentally different. The freedom of speech, the right of freedom of speech talks about the right to express yourself and state ideas, which is reasonable to believe that a company can have this right, or they need to make company statements and have advertisement. While the right to free exercise of religion is one's personal freedom to fulfill their spiritual needs and in the manner of their choosing. It would be unreasonably reasonable to believe a company like Apple to pray or receive Holy Communion. However, the Affordable Care Act is still constitutional and passes both the rational basis review and the strict scrutiny standard. The rational basis review, it passes the rational basis review because it is a law of general applicability. This means that it applies to all people evenly. The rational basis review has two criteria. It must be a legitimate purpose and rationally related to said purpose. Promoting women's health care is a legitimate purpose, and we know that it's rationally related to this purpose because an outside, independent organization was commissioned to research whether these contraceptives would be necessary, and they recommended contraceptives like abortion and birth control. Also, in the Smith case, states that if a generally applicable law prohibiting a religion is not the objective of the tax but merely an incidental of a generally applicable and otherwise valid provision, the First Amendment has not been offended. This means even though providing contraceptives is against Monkey Mastery's religion, they are still legally bound to provide contraceptives. The ACA mandate for contraceptives also passes the strict scrutiny standard. The strict scrutiny has two criteria. One, must be a compelling government interest, and two, must be narrowly tailored to said interest, meaning it cannot be over or under-inclusive. Promoting women's health care is a compelling interest, and we know that it's not over-inclusive because what is included in the Affordable Care Act is only what was recommended by the independent organization. Monkey Mastery is not a religious employer under the Affordable Care Act because it does not meet the standards of the religious employer exemption underneath the Affordable Care Act. The standard is, one must oppose all contraceptives, be a non-for-profit organization, hold itself as a religious organization, and have a certification that fulfills all criteria on record upon request for inspection. Monkey Mastery does not have the two most important criteria for this standard. It is a for-profit organization, and it does not have the certification proving that it is a religious employer. The only other exemption of a law based on religion was in the Storman versus Selecki case, where they were only exempted from the law because they were a family-owned business. May I conclude? Because they were a family-owned business with no public shares, unlike Monkey Mastery. For these reasons, we asked the court to prove that the Affordable Care Act is constitutional and that Monkey Mastery is not a religious employer and is not exempted from the law.
Okay, we're gonna begin the 10-minute.
I have a question for the petitioner. Just